Hello, everyone. Welcome to the WR Immigration Insights on the International Entrepreneur Parole Rule. It is a pleasure to welcome you today to our webinar. This webinar will run for approximately 1 hour. Joining me today is my partner, Joe Barnett. Joe, thank you. Joe is the guy who did much of the work in putting our PowerPoint together. And pardon that slight interruption. So our presentation today is on insights on the Entrepreneur Parole Program. Just to use up a little bit of time and give folks a minute or two to join us today. This program is not new. It is a program that was introduced several years ago. The Trump administration attempted to pull the program, and fortunately, a court struck down that attempt. So we're back in operation. Just to give our audience a minute or two to join us today, I will be starting in about 30 seconds. Just wanted to give folks a second to log on and join us here today. For those of you who have questions, please use the chat function. If you have any questions that are not answered or not appropriate for the chat column, please feel free to reach out to either me directly via email or to my partner, Joe Barnett. The reason I selected my partner, Joe Barnett, to work with me on this presentation today is Joe is an EB5 lawyer extraordinaire. And in fact, congratulations, Joe. I note you just got appointed to the EB5 committee, the AILA EB5 committee, which is a great honor. And of course, reflects your knowledge and expertise in the area. So without further ado, let's kick off, get into the substance of the International Entrepreneur Parole Program. Little bit about our firm, WR Immigration. We're claiming to be a top-rated immigration firm. We'll see if that's true. I love talking about Rapid. Rapid is our immigrant management software system. This is a cloud-based application. Everybody says they have the best technology. This is the best technology. For those of you who are interested, but that's not our topic for today. But Rapid is really revolutionizing the way we practice immigration law using artificial intelligence, et cetera, et cetera. And this is our private client services group doing this presentation. There we are. That is what I call a fake picture because it's a couple years old, but it's still me. And there's Joe, my smart partner, Bernard at Wolfsdorf.com, and my partner, Joe Barnett, J Barnett at Wolfsdorf.com. Joey, as I said, is somewhat of an expert in the EB5 arena, and there are some commonalities that would be relevant. The typical and usual legal disclaimer: none of this constitutes legal advice, so please contact a lawyer if you need legal advice. This is merely a informational presentation which hopefully will provide some useful information. I notice our chat column is getting active, so that hopefully is good. All right, so let's kick off with the history of the International Entrepreneur Parole Program. This program was, in fact, proposed during the Obama administration in August 2016. very close to the end of the Obama administration. They did a focus on entrepreneurs. They discovered, for example, that I believe the statistic was something like 50% of the startups in America were created by immigrants and the children of immigrants. So immigrants tend to be very active in the entrepreneur role, ready to take a chance. And the Obama administration attempted to benefit those folks who may be able to contribute jobs and help in startups. This is about startups. So this is not a permanent solution. It allows entrepreneurs to stay in the US temporarily while starting and growing their companies. So it's to start and grow. The Trump administration, in its restrictive view towards immigration, attempted to postpone the final rule and then tried to eliminate it. The good news is a judge struck that down. Many of the administration's attempts to limit immigration have been struck down, and this program is back in operation with, we believe, some level of support. I do want to caution that as a general rule, parole has always been difficult to obtain. This is not going to be an open and shut framework, but it certainly provides an avenue and a path for certain people seeking to stay in the US. So let's run through the requirements. Again, the foreign national seeking parole, remember, parole is not a visa. Arguably, it's not even status, but it is permission to remain in the United States. We used to refer to it as permission from the Attorney General to stay in the United States. So the requirements, again, a minimum 10% ownership, central and active role in operations. I think this is really important, central and active role. We have some of this in the E2 context, direct and manage, central and active. So, you know, this person really has to have the qualifications and skills. If your client has a background in business, science, degrees, education, obviously all of that will be critical, but having the resume to support the application is going to be important. We do have a 5-year look back. So for those of you who have invested or been able to raise capital in the past 5 years, we can go back. I'm a lawyer, so counting 5 years and going backwards will take a little while, but I shouldn't make those bad jokes. But I guess any investment post 2016 could in fact qualify the individual to obtain a parole. So received, here's the punchline, received substantial capital investments or awards. Now, you know, within 18 months get government grants. How often are government grants given to foreign nationals? Well, if they have green cards, yeah. What about foreign nationals without status? I don't know. I find this kind of unlikely and fairly limited, but maybe there. It may be that the government's going to give some individual a grant. Obviously, if the person got a government grant, that's probably a very strong incentive. But my feeling is that it's not going to be so easy for foreign nationals or their companies. Remember, it's the company that is getting the funding. So maybe the company can get government grants of $100,000, which would open the door. But alternatively, if one cannot get a government grant to fund the company and the startup, the alternative is to get money from qualified investors. And I have to emphasize the word qualified investors, because there's a little trap in there. It's not 250 from investors, meaning your mother and your father, or best friends, or brothers and sisters, or uncles and aunts. It's qualified investors alone. So that's quite something. And then here's the good news. Each company can sponsor up to 3 entrepreneurs, and that's 3 entrepreneur families. So thinking about this one, not bad. Got 100,000 grant. Technically, it's going to let in 3 individuals who may be eligible, you and your 2 best buddies from the home country who worked on this amazing invention. Wow. Looking at it that way, perhaps these amounts are not unduly onerous, but again, qualified investors. So let's talk about.
Ernie, before we go there, I just want to mention this is for those requirements that we were just talking about were for the initial period of parole.
Correct.
Which can be granted up for 2.5 years. And I think like all parole, there's a discretionary element to this as well. And so that's another requirement.
I think that's really important, and we'll dive into that a little bit more. Where, and I was just thinking about this morning. It's like with an E2, I like to tell clients minimum 150, possibly 200, depending where you're applying. And then I love when I do E2 presentations asking, what's the minimum amount you've ever got? People have got E's for like 25 and 50,000 investment. So I think your point, Joe, is really valid, because what if the investment is $25,000 from a venture capital and you're in your garage, but you have the best business plan that Joey and his partners put together? Is that a case? Well, you know, so what? Apply. If it's rejected, what did you lose? So I'm going to talk about that. We'll develop that a little bit further. Those are the basic guidelines, but there are provisions, I believe, that will allow us to look at other alternatives with possible slightly less amounts. So where does the money come from? I want to sort of hone in on this point, because it really has to come from venture capital firms, angel investors. Although the term angel investors is very broad, or startup accelerators, that's the fundamental focus. Here's the issue. They have to have a history of investment in successful startups, investing at least $600,000 in the past 5 years. That's probably not a lot, but if it's your uncle or aunt and they don't have that track record of investing, there's some issues here. And
not just that, Bernie, the entities in which they have invested, at least 2 of them must have created at least 5 qualified jobs or generated, I think, $500,000 in revenue. So it's not just the investment, it's that they have investment and job creation has resulted from it. That's sort of the basis for the parole. They have a history of creating jobs, and that's why the US government is allowing the foreign national here to come in, is because they have that history of success, that track record.
It always comes down to job creation. These investor programs like the EB5 program, this is not per se an investment program. It is a job creation program again. So always the focus being on jobs and job creation. And Joe, the point you made is very relevant, because how do we get documents from these people about their past achievement? Really, these VCs, maybe within VCs, they've got a fancy brochure, but asking angel investors to provide this kind of documentation in regard to their prior, it's kind of proprietary stuff, and getting evidence of employment, etc. So I do see issues and challenges in that arena, and I thank you, Joe, for raising that particular
And on
point.
top of that, for the actual investment into this startup entity that's being used, they almost do a source of funds light, quasi source of funds type analysis where they want to, look at the qualified investors' bank records or tax records, or, showing the trail of money going into the startup entity from that investor.
The exhibit list for these type of cases, I don't think you could use letters from A to Z. I think you'll have to use numbers because it's going to be a long exhibit list, a long checklist of supporting documentation that'll have to be submitted, lengthy index here with documentation. Joe, again, I was actually thinking about that this morning, and I don't think we're going to have the sort of analysis that we have on EB5 and the sort of source of funds and going back, well, you got it from your father, and where did your father get it from? And he got it from his grandfather, and some of the ridiculous requests for evidence that we're getting going back on source. I'm assuming that these cases will not be adjudicated by the IPO. They're not going to be done by the EB5 unit. They will be done by the parole unit in USCIS. So we don't yet know. We will probably find them, but the experience up to this point has not been that enthusiastic. But this is an opportunity. This is a category, and a well put together case will get approved. So, let's be a little bit optimistic. Obstacles are something the government always puts up. But here we are in alternative criteria, the point you raised, Joe. The amount could be less than 250 or 100,000. How much less? We don't know. I would love to have a shot with a $50,000, provided we can meet all of the other alternatives, but I would emphasize that there's no guarantee as to the outcome. I think that if you can show the job creation elements and that the business has potential, always remember, Apple was started in a garage, and, Microsoft, so many of these massive companies that provide hundreds of thousands of jobs were started really as mom and pop shops. This is more onerous. So if the person can provide additional, reliable, and compelling evidence, there we go. Whole lot of opportunities. A significant public benefit to the US. Yep, absolutely. Substantial potential for rapid growth and job creation. Nice, good business plan documenting all of these alternative requirements. And here we go. Large number of users or customers. Already generated high revenue. Well, that's easy. What is your social impact? What is the national scope? Will it have positive effects on locality or region? So now we're going into like the TEA concept from EB5, right, Joe? What about opportunity zones and rural? The whole area where the government has shown a focus on a rural investment, for example. That was a funny pronunciation of rural, but sorry, making fun of myself. But the positive effects, so if you got a letter from the local chamber of commerce, I think that would be...
I almost consider this somewhat even like an NIW type analysis.
Yes.
As well.
Totally.
National interest waiver, yeah.
Yeah, there it is. NIE, that's the word that's in every immigration lawyer's mouth, national interest exception. That's the current framework we live in, but it's national scope, social impact. The government here is being nice. And I would spend a lot of time diving into this arena if we can't get 250,000 from VCs or 100,000 from a public source. So in a nutshell, there we go, folks. We do have a PhD in artificial intelligence. How much does that count for? And what about this amazing idea? Folks, we're getting this like every day. We get people who approach us and they didn't get selected in the H-1B, and they're not quite O1s yet because they don't have enough of a track record. So here's the opportunity to show potential. Generally speaking, in immigration, it's past tense. They want to see you've done it already. This arena, in my opinion, opens us up to the possibility of putting together what I'm going to call a creative but well-balanced application. Joe, I wanted you to talk about one point here, crowdfunding platforms. I mean, that's pretty cool. So we post on a crowdfunding platform. Is that a solution? What's the hook on this one, Joe?
For crowdfunding, the rules doesn't prohibit it, and it could still qualify as long as it meets the qualified investors. I think that's very much easier said than done in terms of actually getting the evidence showing where that money came from. But again, it really kind of depends on how onerous the government's going to be in that requirement.
Yeah, that's my point, is like in crowdfunding, you're not going to get the kind of evidence you need to show past success. I don't think these crowdfunders are going to sort of give you evidence of their employment that was created as a result of some prior investment. So a little bit of a conflict there. Hopefully there will be some latitude from the government if they're going to allow crowdfunding, because it is showing you've got support from the community at large. So, but you know, we are to some degree in untested waters.
Yeah, sorry, Bernie, before we move on to the extension, I will say, I think for this alternative criteria, it's a really great way for foreign nationals and immigration attorneys to be creative and really use all aspects that they can. You know, and I think if you don't have that full amount, and even if you do it, it may be a good idea to include some sort of business plan showing when the jobs are going to be created, showing how you're going to have that significant public benefit. And one of the things that they say in the instructions to the form is that you can include any other, what they call reliable evidence for the company's potential for growth and job creation. And so when I see that, I think of EB5, and I think of economic methodologies that the US government has found to be reliable with regards to indirect and induced jobs. So not only may you be able to show how many W-2 employees are going to be getting on payroll of the startup entity, but if you're going to be generating a significant amount of revenue, then you can likely get more job creation through these economic methodologies. So it may be appropriate to bring in an economist or see if that's something that would help make it a stronger case.
Spoken like an EB5 lawyer, talking about economic impacts, indirect job creation. Direct job creation is very difficult, but indirect job creation based on economic expenditure and outputs using RIMS 2, and certainly that entire concept has been clearly accepted both in EB5 regs and in cases. So yeah, love the idea of moving with direct, indirect, and induced jobs. So, you know, there's a whole scenario. So definitely think job creation here. This is the area where even if you can show the 250, you may want to put in additional documentation to substantiate your case. So definitely alternative is where we're going. And of course, my PowerPoint froze again. Okay, so that's the good. This is the bad and the ugly. I think it is both bad and ugly. But, you know, what can I say? I don't like this onerous extension requirements. You know, this person's come to the US, proven they've made the commitment, proven they have, and the extension requirement is, in my opinion, ridiculously steep. I think we need to agitate for some amelioration here because it's just too tough. But what this tells me as an immigration lawyer is that once you've got that parole, and it's only a single extension, you need to start thinking the day the parole is approved, you need to start thinking, what's next? What is the immigration option here? Maybe this person's making so much money, they can take 900,000 out and do an EB5, right? Put it in EB5 if they've raised enough money. What about an E2 as a follow-up? In order to get this extension for basic requirements, at least 5%, so you can drop from 10 to 5. I mean, really, not very generous, but you know, if the company's taken off, who cares? Signs of significant growth. This is terrible and onerous. We'll go into the weeds a little bit on this. Lawfully operating continues to have potential for rapid growth, job creation, good, continues active and central. So the person has to continue to play that critical and key role in the process. And here we go into the weeds. Investment of at least 500,000. Joey, clarify for me. You don't get to count the initial 250, right? You have to show total investment of an additional 500 on top of the original.
That's yeah. The regulation says during the initial parole period.
Okay.
There's an or though, so it's one of three requirements. It's received at least 500K during that initial parole period, or created at least 5 jobs, qualified jobs during that parole period, or reached
20%.
at least a certain amount of annual revenue during that initial parole period.
Which is quite high because they want revenue growth of at least 20%, which is pretty significant. So what we have here, and this is my problem, $500,000 raised during the 30 months of the initial grant, the 2.5 years, from, again, established investors with a record. And I suppose some crowdfunding is okay. Huge revenue generation of at least $500,000 or annual revenue growth of at least 20% during the initial parole period. So 20% annual growth. What happens if you got 18% 1 year? They're going to cut you some slack. This is quite tough. So again, from the day you get approved, you really need to start focusing on these 3 criteria. Creating 5 full-time jobs, that's 35 hours a week, no job sharing, et cetera, quite onerous, in fact, to create 5 full-time US workers. Be careful there, folks. Refugees, asylees, but non-immigrants don't count. Undocumented, of course, don't count. So the word US workers is specifically defined. Make sure they keep their I-9s up to date. And then again, if you don't meet these requirements, you can submit additional compelling, reliable evidence. So I suspect that the renewal application could be even more complicated than the original. So quite a challenge there, folks, for the renewal. Make sure that when you file and you get your approval, you do not celebrate, but immediately start focusing on the extension requirements, because this is a pretty steep hill to climb. I assume that the government does have discretion, so probably okay. Now, here's another tricky little one. And Joe, thanks for pointing this one out. I almost missed it. What on earth is this? 400% of the annual poverty data income. Now in startups, I've worked on startups where, you know, the CEO is earning like minimum wage because they want to put the money into the company, not into their pockets. That's the sign. In fact, I think generally the idea of CEOs getting high salary is very unusual. Stock options, yeah, sure. But high salary. So everybody should be familiar with poverty datum lines, 400%. I mean, in order to petition for a spouse, it's 125% of annual, but these folks have to draw serious salaries depending on where they live and the size of their families. Otherwise, this is a problem. And I don't get it, but the rule is there. Joe, any comment on public charge? Well, it's not really public charge, but it's the same concept coming backwards. This person has to get a significant salary, presumably as proof that this is a good business. I'm not sure what the logic here is because it just misses me completely.
Yeah, and the only other thing I would say is that in the same subsection where they talk about this, they also, the rule, or excuse me, the regulation also says that DHS can impose any other reasonable condition in its sole discretion.
Yeah, I'm not worried about that, Joe. That's having filed parole cases for many years. It is something that they will put in any parole application. Just give them the power. You know, this could be for security reasons. So it gives them the authority. Generally, we don't see them imposing other restrictions, but I think it's just, you know, DHS wants to cover itself. So I'm not too worried about that one. But I think generally speaking, this is a little bit of a problem. So for those of you who are not familiar with parole, what is parole and what is the entrepreneur parole? Again, parole is not something new. Section 212D5 gives the government the authority to parole individuals into the United States. The general idea was that this parole authority is supposed to be used in a limited manner. By the way, one of the things that I've been pushing for years in order to resolve the EB5 backlog nightmare that Chinese nationals are caught in is that they should give them parole based on the fact that they filed the 526. They've made an investment of $500,000 or 900,000 already. And they're supposed to be able to come to the United States to manage their investment, or if they're doing a direct EB5 to run their company. Why not give the entrepreneur parole to EB5 applicants? It should be. But instead, we have these very narrow requirements that most EB5 folks would not meet. But Joe, let me throw that one out to you. And again, money has to come from the angel investor. In the EB5 context, the money is generally coming from the investor themselves. Do you see a scenario where a direct, let's suppose we have a direct EB5 person who wants to come in ahead? I'm predicting Vietnam has a waiting line currently of about 5 years. I predict it'll go up to maybe 7. India does not have a waiting line, but it's going to pop up, in my opinion, within the next year or two. And what then? And not to mention the Chinese waiting line, which, if we don't get some sort of relief, will continue to take many years before these individuals can arrive. Do you see a scenario in the direct or maybe in the regional center where this could be used, Joe?
Regional center, I think it isn't applicable because only the EB5 investors are actually investing into the new commercial enterprise. You're not having any other investment that goes towards job creation go through that NCE. So I don't think that would be
new commercial enterprise.
Yeah, the new commercial enterprise. I don't think that would be as applicable as a direct case where you know, the EB5 investor puts in the 500K or the 900K, and he's able to also, you know, get this qualified U.S. investor to put some funds in as well, and has that support to show that, you know, with the track record of job creation in the past. So yeah, I do see that being a possibility for direct EB5 investors who are
I mean,
stuck out.
You know, Joe, pooled investments are okay, and many of the direct cases do have U.S. investors pooling. And as soon as they're pooling the appropriate amounts, that I see a direct EB5 that could be structured for a non-E2 country, China, India, Vietnam. I see a new product line coming up of a business where the individual investor invests in order to meet EB5 requirements and also raises money from crowdsource and other options. I think we need to blog about this, Joe. Is direct EB5 also an avenue for entrepreneur parole? And instead of waiting through the backlog, they could at least get 5 years of potential entrepreneur parole to help fill the backlog period. I do see a possibility of, it's a bit of a mix and match, that's for sure, but it's definitely doable in the direct context, but not in the regional center context, perhaps.
Yeah, I guess the only thing that I think about is with the parole, you have to show that you have a central and active role in the company. And when I think of that, and then I think about a direct EB5 business plan and them saying, is this credible? If you don't get that parole granted, then they may say, well, you were supposed to be playing an active role here, and you're not because you didn't get the parole.
How is it going to move? So your point
Yeah.
is basically, if you apply, you better win. Otherwise, it could hurt your EB5 case. Got
Exactly.
it. Joe, you're so deep in the weeds. I love it, but I'm going to be optimistic and say that smart lawyers need to think about that because it's a very important solution. The current solution that most people are doing is purchase a second passport and then do an E2, which is a very expensive alternative to get a second passport through investment and then use that to obtain an E2 to enter while you're waiting for the 5-year, not to mention the issue of non-immigrant intent on an E2 when you've already applied for an EB5. So this is an alternative that might fit a certain limited number of direct cases, provided you can mix and match appropriately. All right, so what is parole? Parole, Section 212D5 of the Act. It's very old. It's been used a lot over the years. When you arrive at the airport and you don't have the correct documents, CBP will routinely parole you in. Well, I don't want to use the word routinely anymore, but could and has the authority to parole you in. USCIS has generally administered the parole, humanitarian parole, but the authority is quite broad within the framework of DHS. So here's one of the issues. The individual does not have unrestricted employment, but is limited to work for the startup alone. So that individual cannot take a part-time job at McDonald's flipping burgers, has to work in the primary enterprise. The spouse, however, has unrestricted. This is nice. The spouse can work in McDonald's. So if both husband and wife are actively involved, I think the decision has to be made very carefully. Who would the principal be and who wants the unrestricted work permit? This is like the E2 where both the spouse is actually in a better situation than the principal E2 investor by having unlimited, unrestricted employment authorization.
And that also helps meeting the income requirements because it's a household income requirement.
Good
well.
one.
Yeah.
Thank you. Yeah. So send your spouse off to work or have your spouse send you off to work, whichever way it goes. But that would be highly beneficial in meeting the 400% of the income, which is required annual income, 400% of the poverty data line annual income in order to get the extension. So the spouse is unrestricted. You have to report any material changes Oh, Joe, what is the most frustrating thing in EB5? Defining what a material change is. Nobody knows what it is. It's never been properly defined. And USCIS, yeah, we support deference, but not if there's material change. And what does material change mean? Nobody knows. Papers have been written. It's what the officer thinks is a
Well,
change. Not necessarily material in my view, but so be it. This is one of the biggest headaches because businesses evolve. So, Joe, if your business starts off as a restaurant, but you have something called COVID and you close the restaurant and you turn it into a ghost kitchen, is that a material change?
I'd argue no. And what's nice
Good
about
luck.
this regulation is that they do define what may constitute a material change. They say, you know, it includes this, but it's not limited to. And they list, I don't know, maybe 7 or 8 different things that constitute a material change.
Give us
But
an
something like that,
example.
I don't think would qualify.
Okay, so you're not neurotic about material change. In EB5, we're neurotic about material change. So just please make sure that before you change the business plan or you make a substantial change to the business plan, you talk to your lawyer. This is not a case of fill up the gas tank and don't think about it again. You need to see where that gas tank level is at all times, because if there are changes in the business, and every good business does change, but the government doesn't always recognize or like that. So let's go into the process now. We have a form. What is it? 15 pages? 15-page form. I guess that's short by today's standards, but whatever. And one files for an I-512 parole authorization. That's the document which allows you to enter the United States. It's not a visa. It is an authorization to enter and engage in activity as permitted by the terms of the parole. The documentation has to be picked up from the US consulate. So if you're in the United States and you are seeking parole, you have to leave in order to get it. And the question, of course, is which consulate, where, and getting an appointment today with COVID. But I'm going to be optimistic and assume that those problems will get resolved. Generally speaking, I believe getting an appointment to pick up a parole will not take months, but I don't know how consulates are going to do it. And we'll probably find that in Belgium, Brussels, it takes 2 days, and in London, it takes 2 months, but whatever. And, you know, if you happen to come from a country such as Iran, which doesn't have a consulate, only designated posts, who knows where or how. But it should be more of a pickup. It's kind of like, in my view, it's like picking up a re-entry permit from the consulate. It's sent to the consulate. I don't think the consul may do a review, depending, I assume, on where you are, but I believe that by the time it's already at the consulate, it's been approved already. Request parole from CBP. That's, of course, when you arrive at the airport. CBP could technically refuse you. You're not coming in with a visa or a green card. CBP may, again, well, what is this all about? Why? Who? Where? What? So be ready, again, to prepare your client, because it's a relatively new product and relatively rare. Canadians can apply at the border. Well, of course, because they don't have to go to the consulate. So Canadians, again, get that sort of special privilege. Initial period, we've already mentioned this, up to 30 months. One additional successive period, we've already mentioned that, and up to 30 months total. So we're looking at a total of 5 years aggregate, which is not bad. If you've got a 7-year wait, 5 years covered by parole, not exactly complete, but covers most of the time. I mentioned this already, the derivatives. So immediate family members need to file the regular, that's the sort of re-entry permit form, the advanced parole form, which is, of course, used for parole as well. Spouses can apply for EADs. Let's hope they don't take as long as some EADs are taking at the moment, 6 to 8 months. Children under 21 are included, but over 21, we have a problem. So we still have this age out scenario, which is not nice. So derivatives still have issues they need to be careful of. So who's going to benefit from this? I think that the one category that would benefit the most are those folks who've had OPT. Everybody knows that for first period OPT, you can do self-employment. And we see a lot of students who set up businesses during the OPT period and don't know where to go next because they don't have an E2 treaty investor option. This is an option, although I always caution people, my preference is always to have visa status. This is not visa status, but it is permission to remain in the US and be employed. So can't always be too picky, but if you can't get an E2 or EB5 and you've got an OPT first period, you can't do OPT extension through self-employment, but initial period you can. Overstays or unlawful entrance. So this is more controversial. It is not clear to me that somebody who's been here out of status for 10 years is a good case. But it appears to me that a person who is out of status or an overstay who may have no other option may want to look at this. One of the nice things about parole is you don't have 3 and 10-year bars to worry about. Or do you? I think people will still look negatively. Remember, for individuals being without status, generally, other than F1s, for example, they won't trigger the bar, 3-year bar or 10-year bar. But if you've been without status, I think it's a very difficult, and we're in new and uncharted territory as to whether or not we're going to be safe in that framework. Generally, this is going to be people who are abroad. So I think students in the US, persons abroad, maybe people here on a B1 business visitor visa and don't have any other options. So if somebody's come in, they can raise funds. Key again is, can you raise funds from a VC or angel investor with a track record? Can you raise funds from a VC or angel investor with a track record? That is the key of who's going to benefit from these. So I think we're pretty much done.
Bernie, there was a great question that was asked in the chat here. If you're on an H-1B, would it be risky to apply? Because if we get rejected, then you've disclosed to USCIS that you are working for your own company, which is, obviously against the H-1B rules. That's the question.
Well, let's talk about that. Are you allowed to be working for your own company? Clearly, H-1B self-employment is not permissible. Clearly, in this scenario, the individual must own at least 10% of the company. If the foreign national owns more than 50% of the company, then the issue comes up as to whether that person could be fired. Well, we all know Steve Jobs was fired from Apple. So there you have an investor who could be fired. And as long as you can be fired, there is an employer-employee relationship. So when setting up the company, even if the foreign national owns 50% or more, if you have an independent board that has authority to hire or fire the foreign national, then you do have an employer-employee relationship such that that individual could have an H. So, Joe, yes, there is an issue with an H-1B. The company has to be very carefully structured such that the individual could be fired. And if that's the case, then the individual is eligible for an H-1. But it's a very difficult
Yeah, I think this
scenario.
question is asking, I have my H-1B employer that I'm working for, but I also have this great startup idea for another type of company.
Well, the rule is quite clear. Well, the rule on a B1 is that you can set up a company, but you can't work in it. You can hire people to do that. If you on an H1, the question, I guess, is can you set up a new business on an H1 but not be employed in it? Is that a legitimate H1B activity? And the answer is you need to be careful. I agree. You need to be careful. If you're on an H1B, I would advise the client to be very careful in terms of going beyond the scope of their H1B. Joe, do you think
and I think it would be difficult as well for the parole if you have to show that active and central role within the company. How are you doing that if you're not authorized to work for it? Just as an owner? I mean, I think you're kind of crossing the line there.
Well, I
It's a
think
blurred line.
the argument is that it's going to be prospective. I mean, we're not doing it now. We're in the process of launching this company, and once launched, we will be in a central and critical role. So, yeah, look, I agree with you. Handing the baton is complicated. Going from step A to step B could be challenging. Is there any advantage for someone in H4 to apply for this parole? No. I mean, if it's an H4 that's in a backlog situation and that person has EAD, I generally would not advise people who have valid non-immigrant status to pursue a category that does not have valid status and is subject to these onerous extension requirements. So the onerous extension requirements are something that are bothering me. I'm hoping they will be interpreted liberally, but no. If you have an H1 or H4, this is for people who do not have a path to a green card or a path to lawful non-immigrant status. I wouldn't sell this above the other options, such as an H1 or H4 or L1 or O1. This is not a preferable. And this entrepreneur parole has to be used together with other lawful avenues to pursue a green card, because on its own, it's a ticket to nowhere. I can see further down the road, E2 preceded EB5, E2 evolved into EB5. I see the possibility, and I really think Congress should be thinking about an entrepreneur visa, which is really the E2, beyond the scope of the 80 or 81 countries that currently can be eligible. So an entrepreneur's visa, a tech visa, a founder's visa. I'm hopeful that this will actually evolve into a non-immigrant entrepreneur visa. It's a starting point. It's a good starting point. I'm very grateful to the Biden administration, and particularly to our director, Alejandro Mayorkas, DHS secretary, who is the one who literally created this. Ali Mayorkas was formerly head of USCIS. He was very focused on entrepreneur rules. He had something called the Entrepreneur in Residence. He put a lot of effort into this. Hats off to DHS Secretary Ali Mayorkas, who's brought it back, who's back in the driver's seat. And that's why I'm optimistic. I am optimistic because the person driving the bus in this instance is somebody who understands business, and I believe will do a really good job when it comes to implementing and hopefully extending as well. So it seems like we've answered all our questions. Joe, do you have any final comments or thoughts for today's webinar?
I guess my concluding thought is this is not EB6. This is not, you know, a permanent pathway, but it can provide some relief to folks who are making those investments and can get them. And it's part of an sort of overall immigration strategy, but it's certainly not the end of it.
It's an arrow in your quiver. It's part of the entire thing. It's definitely helpful to those of us actively engaged in investment visas as well. And you know, we've had a lot of inquiry. We've got cases in process, and I'm enthusiastic that this is a solution for many people. We don't yet know how long they're going to take to process these cases, but considering how everything is backlogged, I'm not expecting a 30-day adjudication. Presumably, one can also request an expedite, as one can on any application, based on the urgent business needs and, of course, the current expedite criteria. So, folks, we are out of time for today. I thank you for joining us all. In order to reach me, my email address, again, my name, Bernard at Wolfsdorf. If you want to email somebody smart and intelligent, it's jbarnett at wolfsdorf.com. As you can see, Joe is the smart one in the couple. I just provide the good looks. And on that silly note, thank you so much, everyone, for joining us today. It's been a true pleasure presenting to you. And until next time, I wish you a pleasant day, and thank you for joining us today. Thank you so much.
Thanks all.